Part 1 of our video presentation on trust administration. My name is Richard Land. I'm an attorney and a member of the Danbury, Connecticut law firm known as Chipman, Mizuko, Emerson. We first published this presentation on trust administration in 2013 and updated it in 2015. Effective January 1st, 2020, Connecticut adopted its version of the Uniform Trust Code, which makes some important changes to the law that relates to trust administration. This series of videos has been updated to include Uniform Trust Code provisions and other more recent developments. In a separate video, we cover estate settlement, from the appointment of an executor or administrator through the whole process of estate settlement, including the final account. Now it's time to talk about trust administration. This presentation was originally the last 3 parts of our estate settlement video, which is also available on YouTube. We thought it would be helpful to offer it as a standalone video devoted to trust administration, so here it is, edited for that purpose. Imagine that you've been named executor and trustee under your friend's will. After your friend passed away, you went through the process of asking the probate court to appoint you executor, and after you were appointed, you went through the process of settling the estate as described in our estate settlement video. Your job as executor is finished. Your friend's will says that all his assets remaining after payment of debts, expenses and taxes, and other legacies and bequests, all those remaining assets are to be distributed to a trust, and you're the trustee. Now, what does that mean? You need to know what a trustee's job is and the perils and risks that you, as trustee, will face during trust administration. And that's what we'll be covering in this part of our presentation. During this part, we'll discuss what a trust is, what trust administration is, and the rules that apply to trust administration. Those rules are typically found in the terms of the trust, and the terms of the trust are usually found in the last will and testament or in a trust agreement. But some of the rules are also found in our statutes, which cover trust relationships. Effective January 1, 2020, many of the statutory rules can be found in the Uniform Trust Code, and the rules are also found in the common law. That means in court cases that have dealt with trust issues starting many hundreds of years ago. So you're a trustee of a trust. To start, perhaps we should have a discussion of what a trust is. Although we talk about a trust as if a trust is an actual thing, or as if trusts are separate legal entities like a corporation, that's not really the case. Rather, a trust is a legally enforceable arrangement, more like a contract than a corporation. And when a trust is created, a trustee takes legal title to the property, and he takes it to hold for the benefit of one or more beneficiaries. So title or ownership is typically divided between the trustee, who has legal title, and a beneficiary, who has beneficial title or equitable title. A trust is defined by a set of instructions, and, as mentioned earlier, you typically find those instructions in a will or trust agreement, and the instructions are implemented or executed according to the law as contained in statutes and in court cases. Trusts can be oral, but they're usually in writing, and there are many reasons for establishing trusts, and the reasons usually boil down to 3 distinct categories. People set up trusts to save taxes, or to try to protect assets from certain risks, such as creditors' claims in bankruptcy, or to provide for the management of assets for someone who is either not interested in or not capable of managing the assets. A trust is created when the creator of the trust, usually called a grantor or a settlor, transfers property to a trustee, and the trustee takes possession of the property, agreeing to follow the set of instructions that the grantor of the trust gives to the trustee at the time. The instructions relate to how the trustee is supposed to manage the property for the benefit of others who are the beneficiaries of the trust. Perhaps it will be helpful if I give you a simple example of a very basic trust arrangement. Let's assume that I want to establish a trust with some cash I have available. I can do that simply by writing the following to the trustee, giving him the cash, and getting him to agree to take the cash subject to my instructions. So here I say, I, the grantor, hereby transfer to George as trustee this bag of cash. George, I want you to pay the income that you earn when you invest the cash to John. And George, if as trustee, you, in your discretion, decide it's appropriate to do so, I'll leave it up to you to decide whether to pay any of the principal to John. At John's death, I want you to pay all the trust assets that then exist to Mary, Harry, and Sarah. The terms of a trust will usually go on for many more pages to describe how a trustee is selected if George is unable to act, and to describe tax and investment powers that the trustee can exercise. And the terms usually provide for quite a few other issues, but I think that this example should give you a basic understanding of what is at the core of the trustee relationship with the beneficiary and the assets of the trust. What is trust administration? Let's begin answering that question by looking at what a typical trustee should be doing. First, the trustee must make decisions relating to the distribution of trust income and principal, and the trustee must make decisions regarding property management and preservation. And the trustee usually is responsible for making investment decisions. The trustee must keep good records and account to the trust beneficiaries, and the trustee must communicate with the trust beneficiaries. The trustee often must satisfy certain disclosure and filing requirements and pay attention to tax reporting. This includes income tax returns at the federal and state level, and perhaps generation skipping taxes and estate taxes. And the trustee should be careful to document the decisions that he or she makes as trustee. And all this trust administration activity revolves around properly serving the interests of the beneficiaries. So let's talk about the trustee-beneficiary relationship. The trustee is a fiduciary, which means the person who is acting as a trustee occupies a position of special confidence, and that person will be held to the highest legal standards for all his actions. The trustee is accountable to the beneficiaries of the trust and will be held liable for any breach of a duty owed to the beneficiaries when the breach causes damage to the beneficiary. We'll get into the duties in a moment. Although the trustee's job revolves around the interests of the beneficiaries, in performing his duties, the trustee will frequently enter into agreements with others. The Uniform Trust Code provides that if the trustee fails to perform an obligation under an agreement that the trustee enters into as trustee, a party to the agreement or a beneficiary of the trust may assert a claim against the trustee in a judicial proceeding. That is a little different from the old common law idea that a trustee is personally responsible for satisfying the terms of any contract the trustee enters into. It may be a small distinction, however, because no matter how you state it, the trustee is exposed to risk if the trustee cannot satisfy the obligations under a contract that the trustee enters into as a trustee. In any event, the trust and its beneficiaries receive the benefits of the contracts, but the trustee, not the trust, is liable for the trustee's breach of a contract. For example, if a trustee enters into an agreement for the purchase of property for the trust, and the trust funds are used to pay a deposit which will not be refunded in the event of the trustee's breach, then upon the trustee's breach and loss of the deposit, the trustee may be liable for the deposit and may be required to reimburse the trust. So a trustee should be careful when entering into contracts for the trust. And of course, if a trustee's negligence in managing trust property causes damage to someone who's not a beneficiary, the trustee will be personally responsible to the damaged party, not the trust.
Now let's get into the trustee's duties. As I just mentioned, the trustee's relationship with the trust beneficiaries is defined by a list of duties that the trustee owes to the trust and to the beneficiaries. Let's quickly go through the list of duties, and as we do, keep in mind that if you're serving as a trustee, a fire-breathing litigator may be watching to pounce on any breach of a duty to hold you responsible for any loss resulting from the breach. As a trustee, in order to protect yourself, you will want to create a clear record that you were true to your duties and that there were no breaches. First and foremost is the duty of loyalty. That's the duty that prohibits self-dealing and prohibits you as a trustee from benefiting from the trust except for reasonable compensation for your services. Examples of self-dealing include a trustee who borrows money from the trust, or who makes a loan of trust funds to a family member who is not a trust beneficiary, or a trustee who purchases a trust asset or sells a trust asset to a family member. These are classic conflict of interest situations, and trustees are supposed to be held to a very high standard, which requires them to avoid even the appearance of impropriety. The next duty is the duty to deal impartially with beneficiaries. This does not mean that a trustee cannot make judgment decisions regarding distributions to one beneficiary over another. In fact, the terms of the trust may require the trustee to make such decisions. But in doing so, the preferences of the grantor of the trust should be what guides the trustee, not the trustee's own personal preferences. In other words, the trustee should honor the grantor's preferences with detached professionalism. Let's quickly run through the remaining duties. There is the trustee's duty to take possession and control the trust property. There is a duty to keep the trust property separated from the trustee's property or the property of anyone else. This is the duty that prohibits commingling. As we prepare accountings for trusts, it still amazes me how frequently the duty not to commingle is breached. It always takes a lot of time to untangle the accounting mess that results from commingling. There's the duty to preserve and protect trust property. For example, the trustee needs to think about things like adequate insurance coverage, safe deposit boxes, and climate control for artwork. There's the duty to try to make trust property productive, to invest to generate income, or to find a tenant for a vacant apartment, and the duty to pay income to the income beneficiaries of the trust. Keep in mind that when the grantor of a trust creates the trust, the grantor can always, within the terms of the trust, change how such duties may be applied. For example, although the trustee typically has the duty to distribute income, the terms of the trust may direct the trustee to do otherwise, and the trustee has a duty to follow the terms of the trust. The trustee has a duty to keep good accounts and to share information with beneficiaries of the trust.
The Uniform Trust Code, which became effective in Connecticut on January 1, 2020, made some important changes in the rules regarding how a trustee must inform beneficiaries of a trust. Section 63B of the UTC says that if a beneficiary asks for it, the trustee must promptly furnish to the beneficiary a copy of the relevant portion of the trust instrument. Also, within 60 days after the trustee accepts his duties as trustee of the trustee must provide notice to the beneficiaries of the trustee's name, address, and telephone number. In addition, within 60 days after a trust becomes irrevocable, the trustee must provide the beneficiaries with notice of the existence of the trust, the identity of the creator of the trust, also known as the settlor or grantor of the trust, notice of the beneficiary's right to request a copy of the trust instrument, and notice of the beneficiary's right to receive a trustee's report. The trustee's report is described in Section 63C of the UTC. It's an annual report that the trustee must send to all current beneficiaries and other qualified beneficiaries who request it. The trustee's report must include a list of trust assets and their respective market values, information about the trust liabilities, information about trust receipts and disbursements, and information about the trustee's compensation. You may have noticed that the UTC refers to different types of beneficiaries. Some beneficiaries are referred to as current beneficiaries and others as qualified beneficiaries. For purposes of the notice requirements that I just described, to paraphrase the UTC a little less precisely than the UTC states it, current beneficiaries are beneficiaries who are entitled to receive payments from the trust at the moment in question, or who are eligible to receive payments from the trust at the moment in question. Qualified beneficiaries include current beneficiaries and other beneficiaries who are entitled to receive trust distributions at the time of a future event, such as the death of the income beneficiary, determined as if the future event occurred at the moment in question. The distinction between current beneficiaries and other qualified beneficiaries makes a difference in how the notice requirements are applied. For example, current beneficiaries are entitled to the annual report described above, even if they do not ask for it. Other qualified beneficiaries are entitled to the annual report only if they ask for it. Now, let's get back to the rest of the trustee's duties.
The trustee has the duty to exercise reasonable care and skill. For most matters, except for investments, this means the trustee must conduct himself with the same skill and care that someone with ordinary prudence would exercise with respect to his or her own property. But there's a special rule for investments. With respect to investments, the trustee must satisfy the prudent investor rule under the Connecticut Uniform Prudent Investor Act, which we will talk about later.
Before enactment of the Uniform Trust Code, there was a duty not to delegate the responsibilities of the trustee. Under the old rule, the trustee had a duty to exercise personal judgment with respect to the administration of the trust. But once again, for investments, there was an exception which actually encouraged the trustee to delegate certain investment management functions when appropriate, and how that works for investments is spelled out in the Connecticut Uniform Prudent Investor Act, which we'll talk about more a little later on. Now, under the Uniform Trust Code, the trustee may delegate other duties and powers that a prudent trustee of comparable skills could properly delegate to an agent under the circumstances, as long as the trustee exercises reasonable care, skill, and caution when making the delegation and reviewing the activities of the person to whom the authority was delegated.
There's a duty to enforce claims that the trust might have against others. For example, if one of the assets of the trust is a promissory note signed by the grantor's son, and the son defaults, it's the trustee's duty to enforce the note, even though that might be a very uncomfortable thing for the trustee to do. And the trustee also has a duty to defend the trust when someone is making a claim against the trust assets. The point of going through all these duties that we just reviewed is to give you some idea of the special status a trustee has and the trustee's special concerns. If the trustee does not understand his special concerns, duties, and responsibilities, and act accordingly, the trustee will expose himself to significant liability. As attorneys, our job is to help the trustee satisfy his duties and avoid exposure to personal liability.
That's the end of part 1 of this video presentation. We hope you found it informative. In Part 2, we'll more fully discuss trust accounting, investing trust assets under the Connecticut Uniform Prudent Investor Act, common challenges trustees deal with, and trustee compensation. Please join us at Part 2. If you have any questions, please let us know. Thank you for viewing.